the first to know Nsem-Pii TV.
Sir, Jebekaya Enra and a former CJ and then a lawyer for 18 Ekokopie mu ewo court. Nina a quite aye fast so no etimi edi efri ho na former CJ and a lawyer for Ekokopie mu ewo court to say CCI John Dramani Mahama etimi e shine na se akonwa a me no e kasa ide yadi nipa foforo e ba besi so enti court no entimi enhote nipa foforo no ayede no e ba besi so no na court no entimi enhwe asem nimu ye because kwan aye fa so eyi ni free so no nyina so papa bia enhwe da emu no na Martin Kpebu and lawyer Edudzi tamaklo NDC lawyer etimi ekokoshia no na enye asem kotoa na lawyer Martin Kpebu se ono de oka e de ato se sa na moto ya NDC amanyeko ya tu dachi bi ese ebesan aba be hante o na de yenko lawyer Martin Kpebu.
Honest with you, you know, lawyers, we like to be guided generally by Supreme Court decisions, right? Because that's the final court. Unfortunately, on this particular one, I don't seem to remember how the Supreme Court has clarified which aspects the High Court can deal with, right? Yeah, so there's not much. Braku Powers agrees that there's no decision that says the High Court can deal with this part and not that part. So now that she has entered, if the lawyers, for the Attorney General will raise the matter of jurisdiction, and when it is done, you see, just like the other one, you know, the removal itself. You see, Dr. Nsem-Pii raised some preliminary some questions to be set down to the Supreme Court. So in the same way, in this case, that's likely to arise. Then that one will be set down for the Supreme Court. Then the Supreme Court will show the way. That one, then we'll learn from it, because matters like this, naturally, if you ask me, as a lawyer, I can espouse a view. But because we've not developed the law that well, the Supreme Court may have a different view. Let's be patient about it. Well, as I've always stated, I wish we would get closure on this matter, right, far earlier. But it appears Justice Tokono is not willing to have closure. She wants to continue going and going. So let's grant her her right, right? Yeah, she has a right to challenge. So when they get in there, the matter of jurisdiction may be raised again for the Supreme Court to determine. And when the Supreme Court determines it, then we'll know. Whichever way, bottom line is at the end of the day, she wants to hold the committee accountable. And that one, she has a right to. As for the accountability, it can never be denied. So whether it will be done in the High Court or Supreme Court, we don't know. But so accountability, yes.
After holding the commission accountable, then what happens? Will she be reinstated? I'm just asking. Is it possible that she can hold them accountable and that would sort of override the decision that has been already taken to remove her? Is it possible? I'm asking you.
Why? Unless it's so egregious.
Because I'm asking myself.
Unless it's so bad, what went on there is so bad that no human institution will countenance it, then that's how she can win. But with what we've seen, there are a few problems. I think, look, in all of this, what she has most going for her, in my estimation, is the failure of the president to give the reasons for the prima facie. Yes, that's that one.
That's the subject matter of the judicial.
No, she's raised it. Hey, let's go.
Sina, if you look at
I'm paraphrasing. Let me show you why she's raised that one there. It will come to haunt us for years to come. Because when that was done to Chatuchikata, we're up in arms that the judiciary didn't do well. They didn't do well, okay? They didn't do well because the Supreme Court itself, when Chatuchikata was not given the prima facie, the Supreme Court itself said the trial judge's failure to give the reasons for the prima facie ruling just shows bias, malice, thoughtlessness. Yes, after saying all that, at the end of the day, they say, but it's not sufficient to cancel the whole trial. So as for, and that's 2003, 2004, Chatuchikata's case. 2003, 2000. So the Supreme Court itself having set that standard that if you don't give reasons, you give way for people to think that you are biased, you are thoughtless, you are malicious, I thought that this one, we should have done it. So, as for the failure to give Tokonu the prima facie reasons, it's bad. It's bad in this process.
No,
but
I
it is
think
not
senior, with respect. No, but senior, you see the reliefs.
Which
here.
one?
No.
And I'll justify. Okay, you read.
Yeah,
Okay,
so senior,
hold on.
I listen there.
No, the reliefs.
You let it
specific
be.
It
reliefs,
says,
yes.
please take note, so and so.
Yes.
For the following reliefs.
Yes.
A, an order of certiorari bringing up into this court for the purpose of being quashed and for quashing the proceedings of 15th of May 2025 and the entire proceedings and the outcome of the Article 146 set up to consider petitions to remove the applicant, chaired by Puama JSC. That's relief A. B, an order of certiorari bringing up into this court for the purpose of being quashed and for quashing each and all of the 3 reasons and grounds given. So grounds and reasons.
Yes. But if not, so when you read it, so now
And so if you go through all the reliefs, she had never questioned, for the purpose of this judicial review, the fact that the prima facie was without reason. In fact, she herself says reasons. Please, with respect. It's not here. At least for this judicial review. Unless, of course, it's a different process. If it's a different process, that's fine.
Let me respond. Please, when you read it, she tells you that that is the foundation. We can get the paragraphs. So what you are reading is the top. It's in there. She says,
reliefs.
Yes. So she's saying that, you see, in law, what she's saying is that in law, you can't put anything or nothing. It will collapse. Mark 4 versus UAC. So lawyers, so she's saying that there's, I read it. Edudzi, I also read it. So she's saying that the relief is the final outcome. Why is she asking for the relief? The reason she's asking for, she says you have no foundation. So anything you put on it will collapse. That's what she's saying. There are several paragraphs where she says she was not given the reasons for the prima facie. So her case is that once she doesn't have the reasons for the prima facie, you can't even do the hearing. And I'm saying that one she won't win, because in the same Chachukikata case, what they did was that they just berated the trial judge for not giving the reasons. But they said it's not sufficient to cancel the case to say, Chikata, because you were not giving reasons for prima facie, walk free. And that one was even a criminal trial, where Chikata's
liberty
excellent. So that one was a higher things were at stake, liberties, right? Personal liberties. Yeah, the Supreme Court said when Justice Henrietta Aban didn't give reasons for the prima facie, though it was bad, it was thoughtless, it was malicious, it showed bias, etc. But still, the fact that Chikata should open his case was a good decision. It should stand. And then Edudzi yourself, you've been citing the other case, 2017. Is it
Michael Asamoah?
But yes, so you also have it. So she will not win. But that one, it will come to haunt us for years to come. That if in 2003, 2004, we said failure to give reasons is bad, it's not good for our governance, why are we repeating that in 2025? That's a separate argument, but that's not sufficient for her to win the case.
Okay.
So let's go on. So now the thing is that, so when you
can I chip something? No, just chip something.
Unless that is on the permission of
Kpebu. Senior, with respect to enrich the conversation.
Yes.
You see, she grounds the reliefs, the 4 reliefs, on specific grounds.
Yes.
And the grounds start from Roman numeral 1
Yes.
to 10.
Yeah.
Each one of them, it is in respect. So, for instance, ground 1, that all of the alleged findings, and ground 4, recommendation of the committee set up by the president, not the prima facie. Roman numeral 2, the findings and recommendations of the committee. 3, the first alleged finding and recommendation. 4, the first alleged finding and recommendation of the Puaman. So throughout, the attack is the Puaman committee. The findings and recommendations. Findings and recommendations. In fact, there is no specific instance that she even brings up the issue of the prima facie determination by the President and the Council of State. And I am making
several paragraphs. When you read it,
the affidavit is there.
Judicial
94.
We are doing law with respect to you. A judicial review has reliefs and grounds.
You've had your so let's go. Look, even before paragraph 94, before paragraph 50, she raised it, but look, another lawyer who has read it says we should start with 94. So let's go to 94 and I'll tell you that before 50 I read it. So let's go straight to 94.
So 94, where exactly are you looking at?
94, I'm just scrolling. Don't say she didn't
it's
raise
94.
It.
Just look at
it's 94.
That the proceedings, the refusal to give me a copy of the alleged prima facie determination, that should have determined what case I was to answer in the proceedings, and the current refusal to also give me a copy of the alleged report allegedly recommending my removal from office as Chief Justice, and the alleged reasons communicated by the Secretary of the President as the reasons given by the Paramount Committee for recommending my removal as Chief Justice from office show a reckless disregard for my rights as a citizen to procedural and substantive justice, and a total lack of any reasons for removing me from office as Chief Justice found in the petitions referred for hearing, and an insistence on presenting any sham excuse for removing me from office while hiding behind the veil of in-camera proceedings, and a refusal to give me a copy of the report as if I do not merit the minimum humane treatment of even being given a copy of the record explaining the reasons for taking my rights and entitlement for me. So after that's the paragraph.
And before paragraph 50.
But she has said that.
Martin, can I just clarify a few things? Let me clarify. You see, when you do a judicial review application, you look for two things, two substantive things, the reliefs and the grounds. The affidavit provides the factual matrices. At this point, what the court is called upon is to give you something, and that is what the relief does. The grounds provides the legal basis why you are seeking for those reliefs.
Oh yes, so that
and the grounds, senior. Can you point out where in any of the 10 grounds formulated that she challenges the prima facie determination? If you do that, I would yield to you.
So, perfect. Now let's go.
Help me out.
Let's start. Paragraph 34.
No, reliefs. I say reliefs and the grounds.
So when I get to the grounds, I'll show you where she said there's an aberration of Article 19, Clause 13 and 23. That's what she's referring to. That she's not had proper justice. 19, 13, and then 23. You see, let's get this. The fact, I've been very clear that the removal is correct.
No, I'm not even disagreeing with you. I'm just saying that we should put the law.
View. Even this is what I'll say. Even if I went to the Supreme Court, this is what I'll say.
I don't disagree with you.
Of a removal, I support it 200%. Okay, it's just that the process you couldn't have gotten 100%. Look, Edudzi, if you want to understand this thing. All of us seated here, even including the professors, how many times when you were in university did you write exams and you got 100%? You won't get 100. So that is the principle we are showing, that the little things that went wrong, but we are not saying it's a failure. It's just to show that the committee couldn't have, the president didn't get 100% in the process. And that one we have the right to show, because it's not good if in 2003, 2004, the Supreme Court said if you don't give reasons, you appear biased, you appear thoughtless, you appear malicious. We shouldn't do that more than 25 years on. We shouldn't do that. That's the point I'm making. But it doesn't mean her removal is correct. No, that one, even if I was called in the Supreme Court, I'm sure I can justify my position that they themselves said it. And so today, you won't find the Supreme Court to say failure to give Tokonu the prima facie ruling is good. The Supreme Court would never be able to do that, considering their own decision in the Chachu Chikata case. And the whole nation was behind Chachu, saying that, why did the trial judge fail to give Chachu Chikata reasons for saying he should open his defense? So if more than 20 years ago, the whole nation was supporting Chachu Chikata and they said, how can it be right now, more than 20 years on, that, failure to give Tokonu reasons is kosher? We can't do that. We will not do that. Even the Supreme Court itself cannot do that. Except that
cannot do what exactly?
Cannot say that failure to give Tokonu reasons is good. That's the point I'm
Senior,
making.
once again, the injunction application, read my Lord Justice Tanko's view, and let me read it. In the injunction application, no, please, can I read?
Okay,
see, hold on. The ruling of Justice Tanko.
Yes.
On the injunction, she raised the specific issue of she not being given the reason for the prima facie. And this is how my Lord Justice Tanko canvassing all your grounds. He said, quote, the next ground on which the applicant invites the court to restrain the committee is that the prima facie determination was not judicious, as it was rendered without reasons. I have cautioned myself against prejudicing the substantive relief sought in the action. However, it is not in doubt the applicant herself has acknowledged the existence of a prima facie determination. She herself has acknowledged the existence of a prima facie determination, however described. Then he proceeds. Whether the form or content of that determination rendered it a nullity due to the alleged absence of reasoning is a matter to be determined at the substantive matter. But I'm saying in this matter, that's not what she had raised. This is the injunction matter. You know it. I don't have a problem. If you are saying that going forward, we should add that to what we do. It's a different matter.
I think that you see,
it's not part of the ground.
Responding to an issue that he raised.
Yes, so you reinforce what I've said.
I don't think so.
You see, I told that.
You wanted to make it, no, you wanted to make it look like it was part of the judicial review.
You couldn't have said the figure is correct. He says it falls to be determined. Yes.
Read the whole thing.
So now let's go to 34. 34 says that my position is that having been directed to hear 3 petitions on 1 warrant, following one purported and yet to be given prima facie determination of the 3 decisions, the committee could not unilaterally determine that its mandate was complete, blah, blah. I told you, there are at least 3 paragraphs. That's 34.
But you see, you are reading affidavit as grounds. How can you do that?
I'm going, you haven't noted that.
No, but how can you do that?
Infelicity of counsel.
That, no, senior. When you formulate grounds of a judicial review and you give relief that you are seeking based on the formulated ground, you cannot use an affidavit to substitute for a ground.
You can do
I don't think we'll settle this on this matter. I don't think we'll settle
Let me continue. Where Edudzi is coming from? He is talking about infelicity of language or infelicity of the language of counsel. And that place is a slippery slope. We all make mistakes. Look, some of the cases we take to court, you know, in a rush, sometimes you write certain things, not leaving court.
I don't think you blame the lawyers.
Look, things happen there. You look at this and say, really, did I write this? You look at the grammar, the syntax. So please, we are looking at the substance. Once the court finds, and I told you that before paragraph 50, I noted it. You see, I've read 34 to you. There are 2 other places she complained about the prima facie. It's the kernel of Tokonu's case. I'm telling you, it's the kernel of Tokonu's case. And that one there, she can beat it for 100 years to come. And she'll be right. We'll be supporting her just as we're supporting the Chikata case. We will be supporting it so that next time the system will do better. Because look, even Nebuchadnezzar Ekufuado, he brought out his ruling. Okujeto said, why did he say so?
No, let's not dwell on. You could have said it without necessarily referring to it.
So let's make the point. Kpebu has asked a petition for the removal of the same Tokonu. Okujeto came on air and said he wrote the prima facie ruling. He wrote it very long, copious. Okujeto, he said he wrote it and Ekufuado signed. So we too, Edudzi, you have many lawyers in the NDC. This could have been done.
What?
writing the prima facie ruling for President Mahama to sign.
I find it extremely uncomfortable when, with respect, an impression is created that the absence of a prima facie, should I say, a reason, prima facie means there was none. At least I just showed you where in the judgment of the court, the ruling by His Lordship Justice Tanko, he says that there is no judicial pronouncement or judicial authority to say that once you do that, the work of the committee is what? Is a nullity. If the work of the committee is not a nullity, and the committee had proceeded, not only that, giving her the right to be heard, appeared with her lawyers, it had gone through the motions, come to the conclusion and recommended her removal. Why are we going back to this belated? This can be the questions of, it can be the questions of reform. It can be the question of reform. It should be a question of reform.
So now we show you
if you want reform, say it. But to try to...
hold on.
The process couldn't have been 100%. That one will say it loud and clear. Talk on the process of the Puaman committee. It's not 100%. That one, nobody can stop us from saying.
The prima facie part of the work of the Puaman committee? No.
She's saying that so the committee should have said, Madam, if you don't have the prima facie, then we will wait. Let's
give you the opportunity.
Yes, please. Okay. That one nobody can gag us. The fact that we support the removal doesn't mean we support everything willy-nilly. Because tomorrow it could be me. Tomorrow they say, because we just thought that the grounds are strong. You see, let's not make a mistake. As for the grounds for her removal, they are very strong, very, very justified, 150%, or like 200%. But as for the process, the prima facie, I'll be consistent. Exactly. The failure to give a prima facie, it's not kosher. It's not on. Let's not repeat that next time. Now, let's go on. So, I've shown paragraph 94, 30, is it 34 I read? The one we read. There are two other paragraphs. Yesterday, I remember reading them before paragraph 50. You see two other ones. Now, Edudzi, let's answer you. When you said the grounds, where in the grounds? Do you see the grounds? The ones talking about violation of article, look at 8. The entire proceedings and grounds of the said Puaman committee for removal of the Chief Justice from office are a violation of the applicant's constitutional rights contained in Article 19(3) and 23. That is it. So she's saying...
Who determined the prima facie? Whose responsibility? Assuming...
Is the president. So she's saying that when she didn't get it. She's saying that,
I just read what she read.
Yes, she's saying that when she didn't get it, and you, the committee, you were constituted, you were to ask the president to bring it forth, let her see, and then you, the committee, would also see. So that one, let's not take it. The fact that the removal is correct doesn't mean everything was correct, because we don't want this thing to repeat itself again.
So these are for reforms. Thank you. That is clear. These are for reforms, but it does not in any way undermine what has been done.
It does a certain extent, but not sufficient to remove it. Did you get the point? It undermines the process a bit, but it doesn't meet the threshold to say that the removal is illegal. Just as in the Chatichikata case.
These are policy issues.
No, it's not policy. It undermines the process a bit. But in the Chatichikata case, the Supreme Court said, when Justice Abban Henrietta didn't give you the reasons for saying you should open your defense, it was thoughtless, it was malicious, okay, etc. But it's not sufficient to say Chatichikata, walk free. So in the